Okay, today we're sitting here with Mr. Dink from Alpine, Arizona, and we're sitting in the Bear Wallow
Cafe.
The best hamburger on the White Mountain, I swear to it.
Okay.
Okay.
All right. I'll go for that.
Dink, I'd like for you to tell us how you got interested in the allodial title, land patent, and why it's important going forward in our country.
Well, primarily, I got interested in it because my family had a ranch near here, and my father always referred to the ranch as patented land opposed to the lease or the permit, which was federal land. And he always referred to it as patented land, and I wasn't quite sure what that meant. And so in later years I began to study and find out that a lot of the ranches here and the privately held properties were originally government land that had been homesteaded, and through the Homestead Act the government eventually granted title in the form of a patent to these ranchers and farmers. And I learned from that patent gave that rancher or that farmer his land in what was called fee simple or absolute title. That having been said, with absolute title, that party or that rancher had certain rights that went with that patent that were considered appurtenances, and they dealt with water and timber and mining and other issues of natural resource. It became very important when it came to water rights, because the water rights were actually issued by the state, in so much as the state issued what they call a water certificate, was your right to utilize water. And sometimes, and especially in this area, that water would be on the water source itself would actually be on government or federal lands. Now, people want to call it public lands, and they argue back and forth as to who it belongs to. Is the Forest Service managing it? Is the BLM managing it? Does it belong to this one or that one? And I never get into those arguments because they could go on for decades. But what I do know is that water that may originate on, for example, national forest, that flowed to that patented land and was put to its most beneficial use, mostly watering cattle, but it could be gardens and other things, and it could even be domestic water. But there was a dispute for many years about that water as it flowed to the land, and the Forest Service for many years charged a fee or a permit, special use permit, for the transmission of that water from point A to point B. Now take into consideration that water is located on federal land, but the water itself is considered by court decree the property of that person who puts a claim against it with the state in which they reside. In 1890, they decreed that all of the patented land west of the 100th meridian, which is very important, the 100th meridian, that all of that land that was patented, that those ditches and canals and waterways, pipelines, whatever it be, would be appurtenant to the land held under patent, which simply means that he didn't have surface title to and surface rights, but that he basically had that easement, that ditch, that canal, that pipeline, and therefore they could not charge a fee for it. Okay, and they've been doing that for years. This can be found in their own book in United States Code, Title 43, Public Lands, and it can be found in there. And from that, what I'm getting at is that that was one of the issues that made the patent an important instrument. Okay. Secondly, the fact that that patent allows that rancher or farmer to hold that land in fee simple, which means absolute ownership, it means also that the state and or the federal government does not have an interest in that property. That party owns it outright, and the interest from that party can be transferred to heirs and assigns. Well, most of us today would not be heirs, okay, because of the time lapse.
Right.
So what we would be assigns. And in order for us to benefit from the patent as it transfers from heirs to assigns, we must acknowledge and declare our patent rights. Now, most of those patents were an average of 160 acres. But all you or I may own today is 2.5 acres or an acre or a quarter of an acre. It has a legal description. But at one time it was part and parcel of a whole. We can declare the patent rights for our portion of that patent. Now, we can't declare them for any more than what we have in the way of a legal description on our present paperwork. But we can declare that and file it with your county recorder, declaring that patent and the appurtenances that go with it, the rights and the things that go with it. In effect, when you do that, you are actually one step above what most people call homesteading. They have a homestead on their property. Well, in Arizona, it's an automatic. Some states it's not. You have to declare it. Arizona is an automatic homestead. It's a matter of protection of your primary residence, to prevent it from being taken in litigation from a lien or a lawsuit or whatever. But in essence, what the patent does is it clouds whatever, and it is your title. It is the highest form of title there is, but it clouds it in your favor. And so technically, if it's patented land, you've got to declare that if you go to get a loan against it, and you have to exempt your lien holder from the patent, or you're not going to get the loan. But originally, the government knew that the farmers would get in debt. The ranchers would get in debt. So they set it up this way so that if they borrowed money against it, the lien holder could put the lender could put a lien against it, but couldn't force you to sell it. Okay, they could stop you from doing a lot of things, but if you did sell it, they would be first in line.
So that's why the banks and the counties, in order to protect the lender's interest, if there was a lien against it, that's why they changed all this, so that banks would in fact loan. That's correct. On the land. That's correct. Now, what happened was, and in Arizona in particular, a deed as between the parties, you and me, with notice, is lawful and binding without being recorded. Does not have to be recorded. It only has to be recorded if, in fact,
there is a mortgage against it. For that instrument to be lawful, and if there's a mortgage against it, there has to be a recordation. In your instance and my instance, if we sold it between the two of us as between the parties with notice. Now that note, when I say with notice, that's the way the law reads, and it simply means that I notify you that this land is not recorded, okay? But it doesn't have to be recorded. There is no law that requires it to be recorded to be a bona fide instrument, so long as you know, okay, and I give you ample notice. But what happens is the county, when most people buy property, they will go down and record it, and 90% of the time it's due to the fact that the mortgage holder requires it to be recorded to protect them so that it couldn't be sold out from underneath them before they got out of bed in the morning.